Welcome back to the legal discussion of environmental ethics and justice section. We know that legal persons are not real persons in the ethical sense. What remains to be explored is how legal standing and personhood concepts in the US and internationally are being applied to claims about nature. If the rights of real persons are the full basket of rights available, what legal rights can and should belong to the environment, animals, and other entities? As we shift from a human-centric to an ecocentric approach to standing, what duties should environmental entities have? Will that switch better protect the environment? Would a river be held responsible for flooding or a drowning? Where would the necessary funds come from for lawsuits or restoration? How will we deal with transboundary waters, where part of the river may be granted rights and another part not? We must also ask how nature may claim its rights. Perhaps guardians could be appointed as representatives, or the public may bring litigation on behalf of natural entities without a show of personal standing. In establishing environmental personhood, publicly funded institutions would be needed to represent the interests of nature. New courts might be needed with sufficient knowledge to balance economic development and nature to promote the greater good for the community. People have been extended certain rights and duties or responsibilities under the law. In extending personhood and standing to other entities, we must define their rights and duties or responsibilities as well. There are many details to be worked out. We can turn to our experience to date, though, with environmental personhood and standing in considering these questions. Let's look at our experience so far granting legal rights and personhood to natural entities to help us answer some of these questions. In 2017, the Whanganui River in New Zealand was the first river granted legal personhood. Through legislation, it was declared a living being and granted all the rights, powers, duties, and liabilities of a legal person in New Zealand. The declaration was the result of a 150-year legal battle between the Maori tribe and the New Zealand government, which began when the tribe's fishing rights were challenged by the government so many decades ago. The legislation appoints two guardians responsible for maintaining the river's health and well-being, one from the tribe and one from the government, and creates an office supported by an advisory group and a strategy group. So an institutional framework has been provided that defines who is responsible for protecting the river, funded by the government, although details of how decisions should be made by the guardians or how they will be held accountable are not included in the legislation. But though the river has been declared a person, there is one glitch. Water is not included in its rights of ownership because under New Zealand common law, water cannot be owned. So the consent of the guardians is not legally required to use river water. And existing property rights to parts of the riverbed are still held by commercial companies that are preserved in the legislation. So the guardians must defend the river's legal rights against those existing rights as well. To date, they have chosen not to pursue litigation on behalf of the river. Some environmental projects have been started along the riverbanks. It is still early days in New Zealand But the declaration of environmental personhood for the river is viewed as an encouraging environmental protection that has already encouraged others to consider legal personhood for environmental entities. The New Zealand experience was reached through legislation. Only one country to date has given nature protection at the constitutional level, and that is Ecuador. The constitutional language there states, nature, where life is reproduced and occurs, has the right to integral respect for its existence and for the maintenance and regeneration of its life cycle, structure, functions, and evolutionary processes. All persons, communities, peoples, and nations can call upon public authorities to enforce the rights of nature. In Ecuador, the first case brought by two individuals who also happened to be Ecuadorian, but as you saw, the constitutional language would allow non-Ecuadorian residents and citizens to bring cases. But the first case brought by the two individuals lived close to an area where road expansion was planned, and they argued that the excavation would harm the nearby river. The court agreed and ordered the government to establish plans for remediation of the river, finding for environmental interests rather than development. But when the developer did not comply, there was no money available to sue again to enforce on behalf of the river's rights. In other cases in Ecuador, so far the outcome has been in favor of the developer. The Colombia experience is different. There is no constitutional or legislative provision, but the parliamentary ombudsman there brought an action in 2016 to stop illegal forestry and chemical dumping in the Atraro River. The court took the action up as one seeking protection of constitutional rights and required as a remedy a joint guardianship between the government and local tribes. Similarly, in Colombia in 2018, the Supreme Court held that the Amazon River ecosystem is subject to rights of its own and could be a beneficiary of protection. There are also several court decisions at the regional level in Colombia recognizing the rights of ecosystems and rivers, some of them brought by individuals. So here in Colombia, there's a willingness to define a funding mechanism and also a means for advocating the environmental interests. In 2019, the Bangladesh Supreme Court granted all rivers in that country legal personhood and the right to have legal protection, the first country to grant all its rivers the same legal status as humans. There, people who damage a river can be sued by the court-appointed Natural River Conservation Commission, which is new and was expressly created for the purpose of addressing the legal personhood of all the rivers. This legislation is notable in Bangladesh because all the rivers are included, and a mechanism for enforcement is established through that newly created commission. In Canada, the Magpie River was granted legal personhood by local authorities in 2021 and given 9 rights, including the rights to flow and to be safe from pollution and the right to sue. And in February 2022, Panama became the latest country to recognize the legal rights of nature through legislation. It is too soon to tell how the Canadian and Panama experience will play out. In the United States, cases have considered the legality of local and regional laws granting rights to natural objects. Regulations have gone unchallenged in the Tamaqua Borough in Pennsylvania and in Shapley, Maine, and they have stood. Others have been struck as unconstitutional, including in New Mexico, Grant Township in Pennsylvania, and Toledo. The Lake Erie Bill of Rights was passed in Toledo and was subsequently struck, as we have previously mentioned. The first case where a natural object sued in the U.S. Supreme Court is the Colorado River System versus the state of Colorado in 2017. The suit was withdrawn after threats of financial sanctions by those who had brought the suit from the Attorney General of Colorado, claiming abuse of process. But in the United States, we have a history starting in 1965 with the Scenic Hudson case against the Federal Power Commission that NGOs have been granted standing from time to time to sue on behalf of environmental interests. So there have been and continue to be some outlets. They must establish standing under the test as we previously discussed, however, which can be difficult. While it's unclear right now whether granting environmental personhood and legal standing to natural entities will better protect the environment, because all of these grants are so new, the shift could be transformative in moving humans away from considering the environment as property solely for human use. Those shifts require time. Let's consider how legal personhood might affect climate change for a minute. While there are many climate lawsuits pending around the world, only a handful involve the rights of nature explicitly. Most climate litigation is brought by persons against corporate or governmental entities who are accused of damaging the climate or not adequately protecting resources. Those who bring climate lawsuits must establish legal standing. A handful of cases from the US, Colombia, Argentina, Peru, and Pakistan have made climate allegations and also asked for environmental personhood and legal standing. So how do the rights of nature fit into the climate crisis? Giving rights to nature represents one legal theory that can help elevate the urgency of protecting biodiversity, which helps combat climate change. And by giving natural objects standing and backed by a constitutional provision, for example, courts may be able to set aside a decision allowing the construction of a new coal-fired power plant, finding that the decision maker lacks authority to allow activities that violate natural systems by exacerbating climate change. It would be unlawful for decision makers to impose liabilities on others, including future generations, by transgressing natural limits. What about animals? Interestingly, a number of endangered species have been granted legal standing, and case names include the species name as the plaintiff. These include the palila, a bird, the spotted owl, and the Mount Graham red squirrel. Naruto, a monkey, was found to have Article 3 standing, but could not establish a cause of action for copyright infringement on a selfie he took with a photographer's camera that was subsequently published by the photographer. However, standing has been denied to the Hawaiian crow under the Endangered Species Act and to Kama the dolphin under the Marine Mammal Protection Act. And in June 2022, Happy the elephant was denied legal personhood in a suit brought on her behalf to free her from the Bronx Zoo to an elephant refuge. Humans have a close connection to animals. There are felony provisions in all 50 states for intentionally killing a cat or a dog, and other laws protecting animals. But the law treats animals as property. While some argue that laws protecting animals are a better approach than granting legal standing. Proponents of animal standing rightfully point out that enforcement is required for protection, and that the next friend standing to bring suit on behalf of an animal can be difficult to establish. In addition, because animals are considered property under the law, their protection is limited. In 2021, a U.S. court for the first time recognized an animal as a legal person. The animals are hippos, descendants of animals imported by Pablo Escobar to Colombia. Colombia has a statute giving animals standing to bring lawsuits to protect their interests. A U.S. court hearing the case for pursuing discovery in the United States to be used in the foreign proceeding applied the Colombian statute granting animals standing. This is another precedent moving the U.S. courts closer towards standing for animals. How to discern the true wishes of another species? As we've touched upon throughout this program, it is difficult to discern what other entities require when we do not speak their language. But we must try. We must look at legal personhood as a continuum, with different rights and duties granted to each natural entity. Finally, we've seen very recently that standing doesn't solve every issue. The deeply complex and stirring struggle under Roe v. Wade and Dobbs v. Jackson, and the challenges of abortion and fetal personhood. In 1973, the court concluded that the word person used in applying the protections of the 14th Amendment does not include the unborn. Almost 50 years later, in 2022, the court reversed itself, holding that there is no constitutional right to abortion. The court specifically declined to weigh in on fetal personhood, stating it was giving no opinion on whether prenatal life is entitled to any of the rights that connect after birth, or what those rights might be. That question is likely to be litigated for decades to come. In this discussion, we have explored human framing and challenges to applying legal standing and personhood to natural objects. Next, we consider the increasing urgency of the environment and potential solutions.